Hello, and welcome to Relitigated, the show where five friends who are absolutely not lawyers attempt to retry a real Supreme Court case. I'm your host, Nikki, and this is episode 17, Griggs versus Duke Power Company, decided in 1971. Two quick notes before we get started. First, as always, we try our best to represent the facts and decisions in the case as accurately as possible, but we're not lawyers, and nothing in this episode should be taken as legal advice. Second, when we talk about the Duke Power Company in this episode, we are commenting on a specific historical event. We are not discussing the current policies, operations, or leadership of the company. With that out of the way, let's start the show.
No, everything is awesome. It's
You need to be strategic with your diversity.
Yes.
Yes. And speaking of, hi there. Welcome to the Relitigated podcast. I'm your host, Nikki, and I'm joined by my co-host, Jarrett. Hello, Jarrett.
Hello.
We also have with us three friends who will be role-playing as our justices. First, we have Associate Justice Mike.
Hello.
Next, we have Associate Justice Serena.
Hey.
And lastly, we have our Chief Justice, Sarah.
Thank you for having me, yet again, somehow.
If you're new to the show, here's how this works. Jarrett and I have selected a real Supreme Court case, and our justices do not know what case we have selected. Jarrett will introduce the case to us and walk us through the facts so we can all get familiar with the details. The justices are free to ask factual questions during this time, and we will answer as best as we can. Next, we'll move into oral arguments where Jarrett will role play as the petitioner and I will role play as the respondent. We each get 7 minutes to make our case, during which the justices can interrupt us and ask probing questions. When the arguments are over, the justices will deliberate and deliver their own opinions. The final rulings do not need to be unanimous. Majority opinion wins. Even if two or more justices agree in principle, they can disagree as to why. Once we've had our fun with our mock hearing, Jarrett and I will reveal what the Supreme Court really decided and talk about how we feel about the actual results and why this case matters. Sound good to everyone?
Yep, sounds great.
Totes.
Awesome. I'm going to turn it over to Jarrett.
All right. The case before the court for this episode is Griggs v. Duke Power Company. Now, our story starts in Eden, North Carolina at the Dan River Stream Station power plant owned by, you guessed it, the Duke Power Company. Around the time of the case, the power plant was separated into 5 divisions: labor, coal handling, operation, maintenance, and laboratory and tests. According to company policy, white employees were eligible to work in all 5 divisions, while black employees were only allowed to work in the labor division, where the highest paid position earned less than the lowest paid positions in the other divisions. Eventually, this overtly discriminatory policy was changed. Gone was the restriction of black employees solely to the labor division. Instead, the company decided that joining any division other than the labor division, either through direct hiring or transfer, would require a high school diploma. This means if you worked in the labor division and wanted to transfer to any other division, you were required to have your high school diploma. Any employee already working in one of the non-labor divisions, who did not have a high school diploma, was grandfathered in, so they kept their jobs and could be promoted within their unit. The high school diploma was only required if they wanted to transfer to a different division. This policy continued for a decade until passage of the Civil Rights Act. Now, the Civil Rights Act is a very long law, but what we care about for this episode is part of Title VII of the Act, which includes the following provisions. Quote, "It shall be an unlawful employment practice for an employer to limit, segregate, or classify his employees in any way which would deprive or tend to deprive any individual of employment opportunities or otherwise adversely affect his status as an employee because of such individual's race, color, religion, sex, or national origin, notwithstanding any other provision of this title, it shall not be an unlawful employment practice for an employer to give and to act upon the results of any professionally developed ability test, provided that such test, its administration, or action upon the results is not designed, intended, or used to discriminate because of race, color, religion, sex, or national origin. To summarize, employers cannot discriminate against employees because of race, color, religion, sex, or national origin, but they can use tests developed by professionals in making employment decisions, provided that those tests and the administration of those tests don't violate the previously mentioned clause that you cannot discriminate. That makes sense?
Yes.
Crystal clear.
Okay. Following passage of the law, the Duke Power Company amended their policies. Now, a basic test was instituted in order to be hired into the labor division, while passage of two standardized tests, specifically the Wunderlich and Bennett tests, was required in lieu of a high school diploma for the other divisions. So to join labor, you didn't need a high school diploma, and you just had to pass a very simple test. While to join the other divisions, you would need a high school diploma, or if you didn't have a high school diploma, you had to pass both of these standardized tests. Again, for employees without a high school diploma already working in a non-labor division, they were allowed to keep their jobs and they remained eligible for promotion within their unit without having to pass the tests. As for transferring, a high school diploma was still required until the white employees who didn't have high school diplomas protested. So then the policy was changed so that if you didn't have a high school diploma, you could transfer. You just had to pass the two standardized tests. In response to these changes, 13 of the Black employees of the company filed a complaint with the Equal Employment Opportunity Commission, which is also known as the EEOC, alleging discriminatory labor practices. The EEOC sent 2 investigators to speak with individuals at the site of the power plant and with company leaders. According to their report, they found few satisfactory answers to their questions. While the company did eliminate segregated locker rooms immediately after the inspector's visit, it did not prevent the EEOC from endorsing the complaints of the Black power plant workers. So the EEOC agreed that there was still discrimination. Now, it's important to understand that the Civil Rights Act was a controversial and difficult bill to get passed, and that for the sake of getting it through Congress, a lot of things were left out of it that civil rights advocates would have liked to see. One of the things that was dropped was giving the EEOC enforcement capabilities. Instead, according to the Act, the EEOC could only, quote, endeavor to eliminate any such alleged unlawful employment practice by informal methods of conference, conciliation, and persuasion, end quote. Any real enforcement mechanisms were reserved for the Justice Department. So the EEOC could not bring a case against somebody. They could just argue with them to be better. So, following endorsement of the claims of the Black employees, the EEOC could only meet with company officials and try to influence them to change their ways. This was delayed due to the EEOC's workload, and when a meeting was finally had, it was not productive. As a result, a lawyer associated with the Legal Defense Fund filed a discrimination suit as a class action on behalf of the Black workers at the power plant. The district court rejected the findings of the EEOC, arguing that since 2 Black employees had obtained roles that were previously held by white employees, that Duke Power was no longer discriminating, and that while past discrimination may have impacts in the future, the company's current policies were not responsible for the effects of prior policies. Additionally, using tests to determine eligibility for roles was ruled to be reasonable. The Legal Defense Fund appealed the district court ruling to the Fourth Circuit Court of Appeals, which ruled 2-1 in favor of the Duke Power Company, though not without significant discussion over more than 5 months between the 3 justices. Following the second defeat, and after some discussion of their own about whether it was worth appealing to the Supreme Court, The Legal Defense Fund did ultimately opt to appeal. And so the case is before our court to answer the following question. Did the Duke Power Company's employment policies violate Title VII of the Civil Rights Act? We will now take factual questions.
What was the exact complaint of the 13 black employees? Like, what was the discrimination that they were alleging?
They were alleging that the requirement of a high school diploma, as well as the tests, were specifically put in place in order to segregate the black employees from the white employees and continue to make sure that white employees got opportunities that black employees did not. Because at the time of this case, if you look at educational attainment, it was much more likely for a white employee to have that high school diploma than for a black employee to have the high school diploma.
And the tests, would it be less likely for them to be able to pass the tests also? I'm just not familiar with these tests here.
That's the contention.
Gotcha.
I've not taken them. I 100% actually do not know, but I do know that that was the argument.
The Wonderlic was intended to be a measure of general intelligence. And the, what was it? The Bennett was a measure of like mechanical ability.
Okay. All right, so the Bennett makes sense, and the Wonderlic sounds a little sus.
Don't they make quarterbacks take the Wonderlic test?
It's I don't know. I know it's a general aptitude test that, so it anybody could theoretically take it, or it could be administered to anybody.
I guess we don't know. Is it just, do they ask you facts? Is it problem solving? I'm just curious now.
Give me a second. And in the meantime, I think Serena might have had a question. So
We should all take this test at the end of the podcast.
My question was around the tests anyways. One, is this a national standard? But I guess it is. And then I also wanted to know, I think Jarrett had alluded to it before, but what was the percentage breakdown of the current employees that had high school diplomas? Obviously it was probably leaning more towards white people having more diplomas, but I just wanted to know number wise, what was that breakdown, if that was available?
I don't know that we have that. I can tell you, taking a step back. So the Wonderlic is basically, it's a supposed to be sort of a brief test of general cognitive ability and problem solving aptitude. And it's for prospective employees. So it's not restricted to any particular occupation. It's just sort of this very quick, take this and without having to go through the entire rigmarole of a formal IQ test. Here's a quick and dirty estimate.
Okay, so it's like a baby IQ test.
I mean, maybe like a fetal IQ test.
Like super fetal.
I definitely didn't just Google, and I'm not taking a 25 question practice.
I think we all should definitely take this test and compare notes.
The episode needs to end with everybody comparing scores.
Yeah.
Also, apparently, I guess they do give it to NFL players.
Yeah, that's what I thought. I think it's an app. I know for quarterbacks at one point had to take it. I don't know if they still have to take it.
Okay, first question they gave me was a word math problem. Frankie wants a tattoo that will take.
Don't tell us.
I'm telling you the question, not the answer.
Well, in the interest of test security,
Then you mentioned math. I'm out.
I just love the idea of the NFL being like, yeah. We know they gave you a degree, but we also know they didn't teach you anything.
Can you run the ball?
So we don't want an example question.
I want to come to the test fresh.
Another question was, did the power plant give any more reasoning why, not the labor unit needed to have the high school diploma? Was there any specific reasoning associated to the job that would require a high school diploma versus the labor not?
I did not see anything specific from the company in my research, but I will note that there were people who worked in those other divisions who did not have high school diplomas.
And I don't know that I can find your other question regarding
high school education rates
yeah.
at this particular time in this particular place.
Oh, for the general population?
No, just at the company.
At the company.
Yeah.
I think it would be fair to use general rates because we're talking about workforce, right?
Mm-hmm. Yeah.
Guys, this test is really easy.
Get your score and then tell us that it was really easy.
I think I could go pro.
Yeah.
Guys, I'm going to be on the Giants.
You're going to Disney World. I don't think I have any other factual questions at this time. I'm trying to reread all the case info to make sure that my brain is actually computing properly. Because I'm not a lawyer, so takes me a little bit of time to weed through the legalese.
Don't worry, the rest of us are lawyers, so we got you.
Yeah.
And then I guess like how soon after they had made the adjustments post Civil Rights Act, like from like when the white employees started complaining, did they like remove the restriction? Like were they just like
Yeah, so it was, I think within a year of the passing of the Civil Rights Act, they added you could take the test instead of having a high school degree. And it was very shortly after that came out that the white employees who wanted to transfer were like, wait, I should be able to just pass the test to transfer as well.
Yeah.
Now, that transfer only mattered between departments that weren't the labor department. Right? So if you were in the labor department and you wanted to transfer, you still had to have the high school diploma or it was the same.
so just
This is
labor?
confusing.
Why am I so confused right now?
Yeah, I'm really confused too.
Well, which
So,
thing
I think
confuses
it's
you the
most
most?
confusing. Okay, I think what's confusing to me is the fact that the rules at the company keep changing pretty consistently. So I'm trying to keep up
Yeah.
with that.
And
And
they
I'm
sound
also
like they're getting better each time.
it does sound like they're
Yeah.
getting better each time. But so I think go back again to the original complaint of those 13 black employees. You said it was because they they feel it was discriminatory. Like, which part of it did they feel was discriminatory? Like the high school diploma and test requirement for them if they were working in the labor department?
Or high school diploma or test requirement, right? Because it's
Right,
not
or.
both, it's either or.
Yeah, the fact
Yeah.
that was required for career advancement, basically, out of the
Okay.
labor department.
Yeah,
Okay.
Just
and
to
then
make
there was
sure
also the fact that prior to the original restriction was if you are black, you can only work in one division.
yes.
White people can go and work in any division. Then they said, okay, we're getting rid of the race component, but now we're instituting the high school diploma requirement. Now there were there were white people working in the other four divisions who did not have a high school diploma, who could still get promotions, get higher wages, move between divisions.
Right. They were grandfathered in.
Yes. Whereas now the black employees who were stuck in labor.
Okay. So they changed
because
the rules.
They saw white employees who had the same level of education as them, who were allowed an opportunity that they were still not allowed to have.
Right.
But
And therefore
eventually
they
they
weren't
were
getting paid as
allowed
much.
when the high school diploma or the test came into play, right?
So is the question
Right,
maybe
like after that comes into play, could, if you were a black person in labor, be like, okay, let me take the test, and then if you take the test, you advance, or was that not allowed?
Yes, but you could, but also the allegation was that the tests were developed in such a way that
The test.
It was
racist.
much that the test was also racist, basically.
Basically,
yeah.
the test
Okay,
was
okay.
the test was used in such a way.
Okay. They
Yeah.
weaponized the test.
Now I think I got you. Okay.
Yeah.
God
And so
damn it,
it was-
Wonderlick.
Yeah. By the way, educational attainment rates, according to census.gov, in the, well, I can't tell you the year, but in the time period that we are looking at, white individuals are approximately twice as likely to have a college degree as black individuals.
Okay.
Sorry, I say college degree. I mean high school degree.
High school
We're all
diploma.
having a day today. Clearly.
I'm going to
Yeah.
guess the year of this case is 2028.
Correct.
In reference to the Civil Rights Act of 2024.
Yeah.
The next Civil
Okay.
Rights Act is going to be to like take away things away.
Yeah,
With the Civil Rights Act, the revenge or something.
Well, there were 1, 2, 3, 4, 5, 6, 7, 8 Civil Rights Acts that I can pull up immediately. So,
Okay. I don't have any further factual questions. I'm pretty sure I understand what's going on here, and I don't like it. So I'm ready to weigh arguments and enact jurisprudence upon the land.
You sure you're not ready to immediately make up your mind and steadfastly cling to that opinion for the rest of the episode?
I mean, it's a bad look for anybody to side with the company, okay? We'll hear the facts, but like,
All right, so yes, really is her answer to that question.
I don't have a law degree. I don't have to be impartial. Okay.
So really, this hinges on Justices Serena and Mike.
Yes.
I mean,
It's
Associate justices underneath the Chief Justice.
Now, I'm noticing there's no unions involved here.
should we make a union? Can the court declare a union?
That doesn't seem like something a court should be able to do.
I don't know. This is make believe, Mike. Okay.
Then, yes, and everyone gets a pint of ice cream.
Oh,
Okay,
all right.
no los dos.
Yeah.
You unionize and you get ice cream.
Sarah Court goes full reparations.
Yeah.
What else do you want? Name it.
White men can continue to play the blues. Black people get reparations.
And
pet snakes. Everyone gets pet snakes.
Oh man, so much to cut out of this episode.
Okay, well, Jarrett will be representing the petitioners. So when he is ready, we will begin. I have 7 minutes on the clock, and take it away.
All right. Thank you very much. Ms. Chief Justice, and may it please the court, I ask you today to affirm that which the Equal Employment Opportunity Commission has already made plain in their report, that the employment practices of the Duke Power Company are discriminatory against their Black employees in violation of Title VII of the Civil Rights Act. According to the Act, it is illegal for an employer to, quote, limit, segregate, or classify his employees in any way which would deprive or tend to deprive any individual of employment opportunities or otherwise adversely affect his status as an employee, based on things like race, gender, or religion. It is our contention that the company has enacted policies specifically to limit and segregate their employees by race. Sure, they've modified their policies as of late so that they're not just coming out and saying Black people are only allowed to work in the labor division and make less, like they used to, because they used to. But that's exactly what they're trying to do. The reason Duke Power requires a high school diploma is because the majority of Black employees do not have high school diplomas, while most white employees do. By requiring a high school diploma, they are placing Black employees into one group that deprives them of opportunities. and white employees get put into a separate group that has all of the opportunities. It's not as perfect a dividing line as saying black versus white, but it's as close as they can get. Now, we're not saying that low high school education rates among black workers is Duke Power Company's fault. That is the result of a long trail of injustices from slavery through Jim Crow. But the purpose of the Civil Rights Act is to address these inequities, and companies like Duke Power are failing to meet the moment. The company's intention is all the more obvious because they have had white employees with no high school diploma for years. Over a decade. There is clearly no actual need to have a high school degree. And when they did require that white employees have a degree in order to transfer, they got rid of that policy when those white employees protested. So, what is the point of making it a requirement if you can be successful in the role without having the high school degree? There is only one reason, because it is the closest analog that they could get to dividing the population along racial lines: black, no degree; white, degree. As for the two tests that the company instituted, these tests are also not related to job success or job skills. They're just another obstacle placed in the way of equality. They know that segregation in the education system has failed the black community, and they are leveraging that reality again to put their black workers into a bucket that they are unlikely to escape from. Employment practices such as these fly in the face of the Civil Rights Act, especially Title VII. Separate is not equal, but by finding ways to deny opportunities for higher pay and better jobs, they keep this community down. Finally, it's important to note that whether the company intended to discriminate or not ultimately does not and should not matter. Their current policies may not sound to the average person so bad. Needing a high school diploma might seem fair, maybe even well-intended. It's not, of course. I've already shown to you, based off the fact that for over a decade, white employees have done just fine in the job without that requirement. But whether it seems fair doesn't change the fact that it uses a facet of our history and our social context to segregate their workers into buckets by race, and that is a violation of the law. Thank you. I yield to questions.
Wow. I'm going to give out a really rare good job, Jarrett.
Oh, man.
Yeah.
I'm good. I'm done.
Yeah. No, honestly, retire.
Podcast achieved.
Leave on a high note.
Yep.
Thank you
Turn
all
your
for
mic off,
listening.
walk out of the room into the sunset.
If this mic was not mounted to my desk, I would drop it.
Yeah, great job. Clearly I'm not biased, as I said before. I don't really have any questions though. I think that was a pretty solid argument. What say you, the rest of my court?
I agree. I'm in the same camp. I think also, like, had the EEOC had the power that that people initially had wanted, they would have been able to enforce this. And yeah, no notes.
I don't think I have any questions. I will just go for a clarification, I guess. What was the EEOC's recommendation to rectify the situation? Because I don't know if we mentioned that or not.
That's a good question. I don't have the specific answer. I know that they had ruled that the company's practices were discriminatory on their face, and that they needed to be changed. For our part, me as a representative of the group, we would like to see the barriers taken down. We would like to see the company write job descriptions and requirements for roles based off of what is actually needed to do the role. So if you don't need a high school diploma to do a role in the operations group, then don't require it. Don't require it just because it's in the operations group and everyone in the operations group has to have one. Write the requirements that are specific to the actual content of the job that you're trying to fill. That's what I would like to see.
Okay, and if there's people in positions that are unqualified, well, I guess that's not an issue because everyone working there already didn't have high school degrees and other stuff. So,
I mean, some people didn't have high school degrees. I want to say everyone didn't have it, but yeah. So if you're unqualified for role because you would genuinely not be able to be successful in that role, that's fine. But these are roles where people were already proven to be successful. So it's clearly a requirement just for the sake of being discriminatory.
yeah, I gotcha.
I believe my time is up. Or I will keep going.
Nope, your
until
time
I
is
hear
up.
otherwise. Okay, there we go.
Yeah, no, your time's totally up.
Okay. Well, thank you. I yield to opposing counsel, and I put 7 minutes on the clock for them whenever they begin.
All right, let's listen to the bad guys.
Wow.
Before opposing counsel starts, Nikki, I just want to say I hate to see you on this side of history, you know?
It's I now feel like I know a little bit more about what it's like to be Jarrett.
Yeah.
You know, I was on another case with you where you were on the shady side.
Is this the new you, Nikki? I don't what's going on?
Miss Chief Justice, and may it please the court. Employees in the operations and the maintenance departments are supposed to keep complex machinery efficient, reliable, and safe. The laboratory department has to be able to perform water analysis, coal analysis, and track plant operations. The test department has to maintain the accuracy of instruments, gauges, and control devices. People in the coal handling department have to be able to read and comprehend manuals for complex machinery. They also have to operate the machinery in a safe and satisfactory manner. This is all done for the purpose of producing electricity and energy. This is complex work. This is for a necessary basic utility, and the company is required by law to maintain adequate and continuous service. All of these jobs require skill, judgment, and intelligence. And as technology progresses, the business operation is becoming more complex. In recent years, the company has been dealing with roadblocks posed by individuals without education, and this causes issues with employee selection, hiring, transfer, and promotion. Therefore, the company decided to require general intelligence and mechanical skills to operate a major power plant for applicants and employees seeking promotion. Records from Congress shows that the legislators discussed general intelligence and aptitude tests, and that they intended to protect the system where employees can give general ability and intelligence tests to determine the trainability of their employees. These tests were developed and designed by professional psychologists. The Wonderlic was designed to measure general intelligence, and the Bennett Mechanical Comprehension Test was designed to measure aptitude and understanding of mechanical concepts and principles. The tests are sound. They measure what they purport to measure and measure it well. They are not intended or designed to engage in racial discrimination. The EEOC has held that an employer's requirement of particular educational qualifications don't violate the Civil Rights Act. An employer can set qualifications, tests to determine which applicants have the qualifications, and hire and assign and promote on the basis of test performance. The lower court found that the high school education requirement serves a genuine business purpose, and the tests were, quote, a reasonably satisfactory substitute. Employers have to be allowed to be able to use objective, generally accepted standards of intelligence and educational achievement or ability in order to make their decisions. And actually, implementing these objective measures are superior to using uninformed, subjective, and arbitrary judgments in making employment decisions. The educational requirement comes from a legitimate business purpose. The company took it on to improve the quality of the workforce. If employees are unable to read, write, and reason through plant operations, they're not going to be able to keep the plant running, nor will they be able to advance in their careers. And as a matter of fact, some employees have refused promotion and transfer because they did not feel that they could do the work required. The company also provides ways for employers to meet the educational requirements if they don't. So there are some options here. An employee can take the tests and get a passing score, or they could use our tuition refund program that covers 75% of the costs of obtaining a diploma or a GED, or they can just obtain their qualifications independently. There's no intention to discriminate against any employee whatsoever, and there's no requirement in Title VII that employers abandon professionally developed tests just because of differences in backgrounds in education and just because some groups are able to perform better on these tests than members of other groups. The differences in performance are due to historical differences in socioeconomic status between groups, and that has nothing to do with the workplace and the company's obligations to provide power to the public. This employer was using the tests for a legitimate business purpose, so the practice isn't discriminatory. As long as there's a business reason behind the tests and it's not discriminatory in intent, a business should be allowed to use it. If an employer is excluded from using an objective test in these decisions, then the subjective decision-making occurs, and that bears greater potential for discrimination. And with that, I will yield to questions.
Yeah, I have a question. Why were some people able to have and keep their jobs in those 4 other units without having a high school diploma? You said that they refused. Yeah,
they were
ahead.
Grandfathered in under the company policy.
So they were still capable of doing the job without the high school diploma, correct?
They were grandfathered in, yes.
And these were skills that they could learn on the job, correct?
Presumably, although without having the data about their trainability, about their aptitude and their intelligence, it's really hard to say.
What was the before the high school diploma and all of the other qualifications came to be? What were the qualifications for the positions above labor initially?
I don't think there was an education requirement. However, once again, as technology has moved on and as operations have become more complex, that has been taken on to improve the workforce.
What is the time frame between the first time the high school diploma, the initial qualification went in place, to now?
I want to say it was 10 years. I want to say. I think I have to go back and double check, but I'm going to say probably 10 years.
We're at time, but I know Sarah had a question.
Yeah.
I had a question. It has left my brain.
Wait.
So
No, I think actually maybe it was closer to like 5 or 6 years.
this injustice stops now. Standardized tests out the window. Ban them for everybody. Also, ban high school.
I mean, I think we're on our way for that.
Yeah, it sounds like Trump department's doing that.
Yeah.
Nikki, I think we just went straight into deliberation.
Oh yeah, no, the justices were ready and we're making pronouncements. All right, let's do it.
Order in my court. You guys feel free to turn back into clerks.
Fire everybody, hire everybody starting anew. Clean slate.
And nobody has any schooling. I don't want to know about their cognitive abilities. I don't want to know about their soft skills.
We are going on tests of strength.
We've done that power plant. I mean, if there's no school, everyone should just be working for their own electricity. I think that would
Right?
solve it all.
Tend to your own fire, you know? we're going to have a 1 mile test. Wait, we're going to do the fitness
An
gram
obstacle
pacer
co-
test.
Obstacle course.
This society should be based on strength, speed, and agility, not cognitive
Yes.
abilities or high school diplomas, not race or age.
Sarah's
Okay.
describing the plot of the Hunger Games.
Uh,
I say that as a clerk. Excuse me, Chief Justice. I just that's the Hunger Games.
yeah. No, the fucking Hunger Games.
That's right, clerk. We are hungry. Bring us food.
Yes, terribly sorry.
Yeah. What do you know about Peter Malark?
How dare I?
Yeah.
Oh,
No.
less talking, more bringing me lobster and foie gras. Come on.
Run a lap, you know? Okay. Order. I still, how many times have I done this? I don't have a gavel. Adam has a powdered wig. What do I have? Nothing. My words. Yeah. Okay.
Useless. Worthless,
Yeah,
really.
Honestly. Okay. So a couple things are standing out to me initially. First is that I am really biased. In this case, probably towards Jared's argument.
What you want to hear from a judge? That's
I don't have a law degree.
yeah.
This is fake, okay? I can say what I want. And I'm a little bit biased towards Jared's argument because I do feel like there has been some unfairness at this company towards Black employees. However, a little part of Nikki's argument is kind of like the little devil on my shoulder, like screeching into my ear right now, saying,
Oh yeah.
What's wrong with a little cognitive test here and there, right?
It's
like
just
maybe
a light
you don't
cognitive
have
test.
what's
Hey,
the
clerk.
big idea, right? It's nagging at me, right? Like, what's wrong with a little cognitive test? How long would it actually take? High school is 4 years. The Wonderlic test is probably, I don't know, Michael, you started to take it, 10 minutes. Like,
Depends how many questions it is, I guess.
I don't know, you saw it.
Well, that's with 25 questions. I don't know how long it usually
Yeah,
is.
from a factual perspective, I think it's like 20 minutes or
Okay, so
Yeah.
in my oh god, part of me feels
Just
like that
I'm gonna give an
is
example.
very
Here's one of the questions.
Okay.
Dog is to veterinarian as blank is to dentist. And your multiple choice options are stomach, leg, teeth, and eyes.
okay. Is it all multiple choice?
That's from what I can tell based on the practice ones I'm seeing, yes.
That seems accessible.
From the
Hate
list
this.
below, select all of the quadruped mammals that might be found as a pet in a typical American family
Okay,
home.
that one's just I mean
The options are giraffe, hamster, dog, cat, and goldfish.
on the basis of your expertise, Associate Justice Mike, what would you say?
I'm gonna go hamster, dog, and cat. I know a few people that have had giraffes, but it's not typical. And goldfish are not quadruped mammals. They want to be.
How do
but
you know
they're
that?
not. Because I know that. Because I got the last question right about what a dog is to a veterinarian as a blank is to a dentist.
Okay.
Undefeated on this test so far.
Yeah. I mean, based on this so far, I mean, you would be just a prime candidate for maintenance at
Also,
a power plant.
like if this is the test, then you don't need any qualifications to work at anything in this job.
I mean, yeah, I guess you could see how the test is like there is some like it's logic questions, right, which is a little bit of problem solving. There's some big words in there, right, which requires a general, some additional vocabulary than maybe somebody who had never been to school ever in their life would know. I don't know. Serena, what do you think?
Oh, I'm siding with Jared all the way. I mean,
Yeah.
the policy that was people get grandfather in is racism. Like
It's
that was the
definitely is.
and so then we're just building upon that.
Yeah,
I mean,
I think to get to Nikki's point, the people that were grandfathered in should have to take the test.
exactly. Yeah.
Yes.
Given that they weren't, I mean, this is clearly just like making the I cannot articulate well, but I'm gonna pause there.
We're all having a day.
The fact that people were grandfathered in is Nikki defeating her own argument.
Yeah. And like the fact that clearly for many, many years, no high school diploma was needed at all.
Yep.
And now all of a sudden, right after the Civil Rights Act, now we need a high school diploma that clearly does not associate with particular skills for those divisions. I don't know. Seems kind of fishy to me.
Yeah, it's like definitely a little bit too convenient. The grandfathering in.
And when the white workers complained, then that policy went away. But if whenever the black employees complained, they had to bring up a lawsuit. So I don't know. Something's
That
not
being
up.
said, if I was working in a position for 25 years and then they were like, well, you need to qualify for this job you've been doing good for 25 years, I would comply because this is America and I'm scared of losing my health care, but I would not be happy about it.
Yeah, I think the grandfathering in point is like too big to ignore. Like I feel like if they never did that, I don't know, maybe wouldn't seem as cut and dry. Here's the thing, guys. Is this like all right, on
The grandfathering in might make more sense if you had been there for a certain, like if you had been working this job for 15 years and meeting performance requirements, then I guess you could be grandfathered in on experience. But
I just feel like for those of you who haven't listened to Buck v. Bell case, spoilers alert, I just feel like when we talked about Buck v. Bell, the entire court was like, yeah, no, forced sterilization, that's bad. There's no way that our Supreme Court would have ruled that that was okay. And then sure enough, the worst outcome imaginable happened. So a part of me here is like, well, this seems pretty cut and dry. Like the policies are built off of a system of racism. They are negatively affecting and discriminating against the black employees and have been for years. Seems like it would make sense, right? But oh no, the U.S. Supreme Court probably is like, no, this is fine. We love the power plant. Let them do whatever they want. Bring back segregation.
Yeah.
The only thing I'll say as clerk is two things. Number one, no metagaming. And number two, we're not asking you to guess what the real Supreme Court decided. We're asking you to reason through for yourself as if you were the justice.
Well,
I mean, you are correct. The Buck v. Bell case is an atrocity
I just
history.
I have a little bit of,
and it's
I
never
have
been
some
formally
PTSD.
overruled.
See, so forgive me if I have a little bit of pause. Okay.
Yeah, if you haven't listened to it, go back earlier in the season, listen to our interview with Dr. Lombardo. He is amazing, and the episode is amazing. It's full of all the information you don't want. Then come on back and finish this one.
Yeah, I also feel like how different would this case be or would this even be a case if the EEOC could enforce things, you know? Like, if this company really felt like they would get in trouble for continuing to have, like, these layers of discrimination, would they have kept doing it? I don't know.
Side note, but also they dropped the diploma thing for transferring between units. So again, also clearly the high school diploma requirement is not needed. It's really just a barrier to entry.
But is our ruling going to be that they should get rid of like
What
requirements
they
to
should
work
do?
there?
Oh, I think the ruling should be applied to like all departments, the same requirements across all departments, because the divide is just that the labor unit has different requirements versus any other one.
True.
So if you are going to have any requirements, it should be the same across the board, whatever that may be.
Yeah.
Well, I mean, but like if the jobs are really different and one really is just move coal
Well,
from
but
there to there.
I feel like if the jobs are really different, it's kind of like how today when you go to get a job, like most jobs, and I'm just speaking from somebody who works in corporate America, most jobs they require you to have like a high school diploma or a GED as like a baseline, like regardless of anything, or they say a bachelor's or associate's degree is required. It doesn't matter where you work, like you need to have a high school diploma. That's I mean, high school diplomas are obviously way more accessible these days than they probably were back whenever this case happened. But then, like, as the jobs get more technical and nuanced, maybe, then the job descriptions need to reflect, like, hey, as well as having a high school diploma, you need to have a master's degree in, I don't know, computer science. Like, so I'm not saying that you need to have a master's degree to work in coal handling at the freaking power plant, but like, there should be, I think, the company should be required to create job descriptions that match the expertise or the skills that are exactly needed for that specific job instead of just like isolating one random unit of the company. Um, I don't know if that made sense. My stream of consciousness is just kind of going and I'm blacking out.
We might be losing the coal power plant segment of our listening population here. Hope we're not alienating anybody.
Uh, drill baby drill?
I don't think you drill for coal.
I don't know how things work. Okay. Don't ask me. Okay. What else? What else? What else are we thinking?
So, like, I feel like this is discriminatory, but I wonder, like, to the question of did it violate the Civil Rights Act? It's where they can get us.
I think, yeah, I think like based. I mean, it's kind of hard. It's hard to like if you just look at this
I feel like they're
rule.
doing a letter of the law, but not spirit of the law.
Yeah, for sure. I think if you just look at this in a vacuum outside of like the segregation that used to be at the company, it would be easier to just be like, yeah, of course. Like for some jobs, you need to have a high school diploma, and for the labor department, you don't. Doesn't matter. But because the optics are just so terrible. Like it's like what Serena said. Like you never said jack shit about needing a diploma or having to do a cognitive test prior to the civil rights movement. So
Well, no, I think they did, right?
no, it was
Yeah, it
just
was after.
yeah, no, it was after. That's the whole thing. It was like before the civil rights movement and that first change in company policy, they essentially said that if you're black, the only place that you can work in is the labor division. And so they had no opportunity to move in any other department of the company.
Yeah. Well, so
Which,
the high school thing was before the Civil Rights Act, in which you could say that's discriminatory because more white people are likely to have high school.
yeah.
After the Civil Rights Act is when they said, okay, high school diploma or passage of the exam.
Okay, wait, yes, you're right. I was getting ahead of myself. I was thinking I missed the middle there. Just cut everything out. Honestly, let's restart the episode. Just for some reason, the timeline's confusing me.
There are two changes to policy. The first policy, which was there for years, was white people can work anywhere, black people can only work in the power division. Sorry, the labor division.
Yes.
10 years before approximately 10 years before the Civil Rights Act was when the high school diploma went into effect.
Wait, was it?
Yeah.
Hang on.
Oh, wait. So
Wait,
the
hang on. Was that what
Yeah.
happened? I thought it was after.
Yeah.
And then
No,
after
no,
the
it even
Civil
says
Rights
that.
Act
yeah.
is when
Okay.
they said, because the Civil Rights Act Title VII says you can administer a test. Then they said,
Oh, right. Got
okay,
it.
well then we're going to add a test to the requirements.
I mean, which I think is technically following the law.
And then, but in every instance when they added a new requirement, nobody who currently worked in a role was ever asked to prove that they had that requirement.
So to play devil's advocate here, though, if you were in a job and then suddenly a new policy came that a certain certification or something had to be in a required qualification for the job that you had been doing like for 10 years.
I can't answer that question as clerk. I can only answer that question.
I'm asking it to the ether and the other
Okay.
judges.
All right.
In corporate America, I would say we get like yearly trainings, and we get new ones that we have to do if they think it applies to our job.
Yeah, that's accurate.
So that kind of still goes with the argument that the grandfathering is still on the basis of racism, which would allow them to get away with discriminatory practices.
Yeah. No, I definitely agree with you that the grandfathering is suspicious and racist. I think the timeline of when these changes happened are kind of throwing me off now. Like, they enacted the high school diploma requirement way before the Civil Rights Act happened. Which, I mean, I guess it doesn't mean that it wasn't a discriminatory. I mean, obviously it was.
I think that's when it was discriminatory.
Yeah, that's when it was discriminatory. And then after the Civil Rights Act, they allowed the high school diploma or the test, the two tests.
Like, at what point can you pass? Like, okay, you've been doing this job good for 10 years. Like, here, but take this test.
Yeah.
Like that, if I was an employee, that would piss me off.
Yeah, it would piss me off too. But I do feel like it would make things more would absolutely make things more fair if the company was like.
And if the goal of the company, like Nikki was saying, was to improve the entire workforce, then then if you're trying to improve the entire workforce, that would include people that had been there for 10 plus years.
Right.
New ones going forward.
Yeah. You would want to, I mean, and who knows, like, what type of on-the-job training this company was doing, right? Like, who knows? Maybe they were doing, like, a yearly coal handling.
Yeah, I guess that is something that's missing. Yeah.
Also, if someone had been doing the job for 10 plus years and sucked, then you could find out that they sucked through this and get rid of them.
Well, presumably they would have been fired before then if they sucked,
Maybe, but maybe not if they were just, a white guy that was personality hired.
Yeah, it could have been good old boys club, I suppose.
Yeah, good old boys club. Yeah, I think, like, a part of me is like, I do think that the addition of the two cognitive tests does a little bit help with those who weren't able to get a high school diploma. And maybe, like, if you're looking forward, like, if this policy was enacted today, anybody who applies to work at the company in any non-labor division moving forward would have maybe a little bit more of an equal chance, because you don't have to have a high school diploma. You can just pass these two cognitive tests, which take like an hour total, and have a better shot at getting the job. But it just kind of screws over everybody that had worked there before, including the 13 Black employees that raised this case, right? Like, it doesn't really help them if they're already working there. Like they're still victims of this racist system. Maybe it helps people moving forward to get
Yeah.
new jobs, but it doesn't really help people that are already there that are maybe stuck or have been stuck.
Yeah, I guess so. What was this? I know we said it way earlier, but what was the specific complaint of the 13 black employees?
That originally the high school diploma was put in place as a way when they got rid of they were like, well, we're getting rid of the requirement that, only that black people can only work here. But then they added this high school requirement that had never existed before. And they said that was just a way of them having the same policy, but saying it in a different way. And then when the Civil Rights Act came out, they couldn't get away with just doing that, and they had to add this test, but that the test itself was not necessarily a predictor of success in the role. So the test was just added just to meet the basic letter of the law, but it actually served to tighten the restrictions around the black population at the company, where it would seem that it's like, oh, we're trying to give them more opportunity, but were these tests developed with large numbers? Were these tests developed in Ivy League schools done in a way that included large numbers of uh, black individuals who had the standard level of high school education attainment in the country? So was the test really representative?
Yeah, that's a great point. Okay. I've decided on my final answer on this based on that.
I think so, but let me just go back to one more thing from Nikki's case. You said that the company uh, offered educational opportunities.
Yeah, so people can take the test and get a passing score or use a tuition refund program that covers most of the cost of getting a diploma. Or the employer can just go get the qualification. The employee can go get the qualifications themselves.
I almost feel like a big, like what Jarrett was saying, like a big part of the issue here too is like what even is the Wonderlic test and what's the other one, the Bennett test? Like,
Yeah.
what are they? What samples of population are they based on? Like, are these tests even fair to begin with? Like, I don't think as a rule it's outlandish for companies to come up with policies that say you need to have a certain degree or pass these certain certification tests in order to have this job. Like, I think that makes perfect sense, especially to Nikki's argument when you work in an industry where the technology is constantly advancing. I think that's fair, and I think that's still very applicable today. I don't want a doctor without a degree to operate on me, right? But like, is the Wonderlic are the Wonderlic and Bennett tests actually? I mean, I don't know. Like, are they? Now I'm like, at the beginning, I was like, I think they're probably accessible, but now I'm like, wait, are they though? Like, can just like your average person on the street who doesn't have a high school degree that needs a job, like, are they able to pass these types of tests with flying colors? Do they indicate any sort of aptitude in actually being able to do maintenance at a power plant? Like, I don't
Yeah.
know. It
The
gives me
Bennett
pause.
one, the Bennett one you said was a mechanical exam. I've never heard of that one.
The Bennett mechanical comprehension test.
At the risk of being more lawyer than clerk, um, when we were talking about well, somebody who may not have had a high school diploma but got the job before that and was grandfathered in, you know, um, well, maybe they have to take it. Maybe we'll make them take it again. If that person failed the Wonderlic test, wouldn't that show that the Wonderlic test also is not a predictor of success in the role? And so also is clearly not actually doing what the employer says it's doing, which is trying to get the best candidate, if you could take someone who failed it and teach them on the job to do the job satisfactorily.
Yeah. That makes sense. I mean, it's just, it was all wrong to begin with at the Duke Power Company. And
I like that Serena decided like a while ago and is just waiting for you all to figure it out.
yes. I'm trying to flush out everything. Like, I'm trying to go down every little nook and cranny. Like,
I saw the first slide. Like, yep.
Yeah, I'm trying not to use my heart. I'm just trying to use my brain, not my
yes,
heart.
I'm trying to use every ounce of brain power I have. And
Don't
also,
you
I'm
know
trying.
all the best justices decide and then work backwards to rationale.
That's kind of okay. I mean, I came into this being like, I am 100% on Jarrett's side, which is weird to say. And then a little. Nikki made a very tiny bit of compellingness. Had a little bit of compellingness in her argument, and I was like, wait, hold on. Like,
Maybe it's because she
it
didn't
is.
wait until the last second to write her argument.
Yeah. Like, I feel like the Duke Power Company absolutely is. Like, I feel like it's racist. The policies they used to have,
It's a
absolutely
power
racist.
plant in North Carolina before the Civil Rights Act. Yes, it was racist.
It's, of course, it's riddled with racism. It's absolutely an old boys club. Like, but is implementing the Wunderlich and the Bennett, because that's what we're talking about, right? Like, when you say, like, did the Duke Power Company's employment policies violate the Title VII of the Civil Rights Act? The employment policies that we're looking at is the most recent policy change, right? Which is the high school diploma or the cognitive tests. So,
It
like,
seems shitty, but I feel like it might actually be in line with what the law is my hang up.
No, it still feels racist to me. I don't like it. I don't think I get it. Yeah.
I said it feels shitty. Look, there was one episode of this podcast where I had to like side with the cops, and it's kind of giving me PTSD.
Yeah, you're really having to look inward. Who are you, Mike, on the inside? Okay. All right. I think it's time for some closing arguments, unless anybody else has anything else to deliberate.
I think I've made my decision.
Please.
Yeah.
Start us off.
I think I'm going to side on Jarrett's, the petitioner, not partitioner, the petitioner's side.
We're not lawyers. We can't speak.
Because I don't think it's necessarily the fact that there's a requirement, but it seems like the requirements don't necessarily correlate to the actual qualifications needed for the positions. I mean, which I guess someone could argue is that the company's just being stupid and that's not discriminatory, but I've already said my thing and I can't take any backsies.
No take backsies.
That's the rule, right? Like, no backsies.
Yes.
There's only one rule in Sarah Court.
That's no
take
backsies.
these backsies.
Please. Okay. Serena, what arguments would you like to close with today?
Yeah, I'm siding with Jarrett. No surprise. The power plant has a long history of racism, has grandfathered those types of policies into today, whatever year this is, and continue to facilitate discrimination by adding these tests. And according to the Civil Rights Act, it should not be, those results should not be used to discriminate based on race, which to the court, it seems like they are, as how they use these results seem to flip-flop to put white employees in positions of advantage. And I close with that because I cannot talk.
I love it. Okay. Guys, it's going to be a clean sweep for this court today. I am also in rare fashion siding with Jarrett's argument. So yes, everybody let that sink in.
Wow.
I'm siding with Jarrett. I do think I think that there's a lot of issues with the way that this company has enacted their employment policies throughout however long this time period is, 20 years maybe, let's say. Yeah, that's fine.
We haven't been able to really nail that down.
I don't really know. I have no idea exactly how long this has been. I think there's a big issue in the way that they have grandfathered white employees into more favorable working conditions. And I also think that there's probably issues with the actual efficacy of like the Wonderlic and the Bennett tests. Do they provide an accurate snapshot of an employee's capability to do a job? I don't know. I haven't taken it. I'm also not a mechanic, so I would probably fail the Bennett test. So don't hire me. And I also think that I don't know. It just feels icky. The company feels icky. I'm sure they do great things providing energy for their community, but at what cost? You know what I mean? So that's my case, and I'm sticking to it.
All right. So are you guys ready to hear what the real court decided?
Oh my god.
So this case was argued December 14, 1970, and was decided on March 8th, 1971. Justice Brennan did not participate in the consideration or decision of the case, so this was actually decided by 8 justices, and it was a unanimous opinion. The Court of Appeals was reversed. So basically, the court ruled Duke seems sus.
Let's go.
Wow.
So in looking at this, so basically they said that the language of Title VII makes clear Congress's purpose in enacting it. Quote, "It was to achieve equality of employment opportunities and remove barriers that have operated in the past to favor an identifiable group of white employees over other employees." Unquote. This means that even practices, procedures, or tests that look neutral or are intended to be neutral are prohibited if they end up perpetuating prior discriminatory practices. So they talk about freezing the harmful status quo. Therefore, the Act prohibits not only overt discrimination, but it also prohibits practices that end up being discriminatory in impact and consequences. So, in thinking about this, the court took this really deep dive into the history of the Civil Rights Act. So they looked at transcripts or whatever from the debate in Senate before it got enacted. They looked at a memo that was written by the co-managers of the bill, all the various amendments that they thought about in considering what Congress meant when they passed the law. So remember, the Supreme Court's job is to interpret the law written by Congress based on consideration of Congress's intent. So they looked at all of these transcripts and evidence and, had a very clear picture of what Congress intended. Also, the Equal Employment Opportunity Commission, which enforces the law enacted by Congress, issued guidelines interpreting the act that state that only job-related tests can be used. So only tests that measure the knowledge or the skills required by the job and fairly affords the employer a chance to measure the applicant's ability to perform a particular job or class of jobs.
Does this case mark the beginning of modern day job descriptions as we know it?
Sure does. Well, Jarrett will talk about that. Yeah, but this was the case where they were like, if you're going to do a test, you need to have data showing that the test correlates with or is predictive of important job elements. And Congress also said that the employer has the burden of showing that a qualification requirement has a relationship to the job in question. So this whole general, like, oh, let's just see how smart you are, what how smart, what you can do. It needs to be specific. So they were hung up on this fact that there were people in this job who didn't take the test or didn't meet the requirement and were never required to do so. And then they were rising up in the ranks, same as employees who did do all that stuff. So they're like, y'all aren't measuring job performance then. What even is this? And they had a lot of analysis. And basically they said that Congress isn't intending to guarantee a job to everybody, regardless of qualifications. And a person is not required to be hired just because he was formerly the subject of discrimination or due to a minority group status. But what is required is the removal of artificial, arbitrary, and unnecessary barriers to employment when the barriers operate invidiously to discriminate on the basis of racial or other impermissible classification. So if there's an employment practice that effectively excludes a class of people and can't be shown to be related to job performance, that practice has got to go. They also took a look at the at demographics. So they were like, yeah, this test looks neutral and that white employees perform better than Black employees. But if you look at the census data, 34% of white men in that area completed high school compared with 12% of Black men. And during this time, so this case was decided in 1970. So segregation was active. So Black students were deliberately being shunted into schools with inferior resources up until within a generation of this case. So these kids shunted off into these schools, grow up, try to get a job at this factory. And because of sort of this legacy of segregation, they're not performing as well. And they drew this parallel with literacy tests for voter registration. And they were like, yeah, we prohibited those because in practice, that just functions to block Black persons from exercising their right to vote. So they were like, we see what you are doing here, Duke, and we're not having this. And so we're not even going to talk about whether, you need to do some testing for promotion or long range, genuine business needs. And they said, quote, history is filled with examples of men and women who rendered highly effective performance without the conventional badges of accomplishment in terms of certificates, diplomas, or degrees. Diplomas and tests are useful servants, but Congress has mandated the common sense proposition that they are not to become masters of reality.
Wow. There you go.
So I think Serena kind of, I feel like she just immediately was like central issue.
Yep.
And and then was just like done.
saw right through the facade.
Yep.
Come on, guys.
It'd be a pretty boring podcast if we didn't argue about it for at least a little bit.
Fun fact, talking about the quarterbacks taking the Wonderlic test, that actually has been discontinued in 2022. So up until 2022, quarterbacks in the NFL were still taking the Wonderlic test. And I'm seeing here, they're saying that the process was outdated. Duh. Also, there was no statistically significant correlation between a player's Wonderlic score and his on-field performance.
Well, yeah.
That has ever been documented.
They could probably give it now after a concussion.
Yeah, if they wanted to trend.
Yeah.
And I remember hearing
they
about
should
players.
They should give it once a year after each season and just see how performance changes as the CTE kicks in.
So I do recall, and unfortunately I don't remember where I read this, so I can't, cite my source, but there was sort of this practice among players to underperform at their preliminary Wonderlic. So then they go out and then get a couple taps to the head. And then, as part of the testing of how they're doing, they get the test and then they perform the same as they did before. And therefore can continue playing football. I don't remember where I read that though. So
thanks. I hate it.
I still think that we should go back to our original ruling where we should say that The qualifications for all jobs should be an obstacle course race.
Yeah. I do want to see a timed mile from everyone. And
We're looking
bonus.
at how many max pull-ups, how many push-ups can you do in 80 seconds?
How long can you hold your breath underwater?
That's a good one. Yep.
So yeah, this was there was some additional context around this. So after the Civil Rights Act, and this is the one of 1964, by the way, there was a lot of employers who did a whole bunch of changes in their employment actions, and to meet the requirements of the act. And some were genuine in intent, but more often they weren't. And so around this time, a lot of companies started introducing tests and education requirements, which did end up being major barriers to the advancement of minority groups. That, along with seniority provisions. So there was like discussion. I remember there was reading about a whole bunch of lawyers meeting at a conference and being like, so these tests are like bullshit, right? Yeah, they are. Yeah, okay. Because that they all kind of came together and found that was what was going on. And this decision is also notable because here's where the court said that discrimination isn't just some isolated act by one individual or company or party affecting another individual, but here they're conceptualizing it as a more systemic process that adversely affects groups by consequence, independent of motive or purpose or intention. And in a 20th anniversary survey, the original group of plaintiffs in this case, in the Griggs case, all said that after this litigation, they got better jobs and benefited economically from the changes that this led to.
Yep. And then those benefits become generational wealth, generational benefits, and that was the actual goal of the Civil Rights Act. Well, it was one of many goals.
Mm-hmm. And then also, according to this article by Garrow, in 1988, the Supreme Court made some decisions that basically replaced the Griggs standard with a more lenient test for employers. But that doesn't really matter because the Civil Rights Act of 1991 came along and it reversed those rulings, and then it codified the Griggs disparate impact standard into laws. So initially, SCOTUS was like, Griggs and don't be discriminatory in impact. And then 17 years later, they come up with another ruling being like, never mind, just kidding. But then 3 years after that, Congress is like, no discriminatory impacts. Yeah.
And this is the case where the term disparate impact comes from, as far as I understand it. Like, this is the disparate impact case where most people, certainly folks that, that I have worked with over my career in corporate America, can, if I say Griggs v. Duke Power, they have no idea what I'm talking about. I say disparate impact, they know what I'm talking about, or at least have heard the term.
A lot of corporate shills on this podcast today.
So I was very excited to do this case because this is one of my favorite cases. Number one, because just straight up, as you all alluded to, the number of cases where you read it and you're like, there's an obvious right answer. And then you read what the Supreme Court said and you're just like, well, son of a bitch. This is one where I was like, there's an obvious right answer. And then I read the results and I was like, oh, thank God. But so this case for me is really important as somebody who has worked as a manager and supervisor for a long time, who hires people and manages people. So I've worked in technology. I know, Serena, you have worked in technology and software development. There is this concept of what's called the whiteboard interview. And for people who don't work in software development, the way it basically works is they give you a coding problem to do, and you have to code it writing on a whiteboard. And it can be, it's not real code, but like you have to solve the problem. It's basically a logic problem, and you have to solve it with code, and you do it while somebody watches you on the whiteboard. And my hot take is, now I'm not a lawyer, but my hot take is that those kinds of interviews constitutes a test. And because they constitute a test, employers should be expected to validate that the whiteboard questions they ask and the answers that they are given actually relate to the job. And for anyone who listens to this podcast who is in software and has taken a whiteboard exam and gotten the job, I think most would agree that they are asked questions or are asked to solve a problem that they will never be asked to solve on the actual job itself. Like write an algorithm to sort this data. Nobody writes that anymore because libraries do it for you. So I've always been curious if there's an employment law lawyer listening, please reach out to us and let us know, or let me know, because I really want to know, are these whiteboard interviews violations of this principle of, if you're going to create a test, that test has to be an actual valid representation of the skills you actually would use on the job and the kinds of problems you'd have to solve on the job. So that's one thing. Second thing is job descriptions. I think it's been my experience in a couple of different places that I've worked, not all of them, but some of them, that when a new job is like being opened, like they're opening a new role, whoever is going to be the manager of that role, they just say, like, go write a job description. And I feel like an employment lawyer hearing that would be very scared because job descriptions are the same as, and have the same rules. And this is the case that created those rules that said, look, if you're going to put it in the job description, you need to be able to prove that if you require it, it's because it is actually required. You can't just say, like Sarah said earlier, like every job description you see in corporate world is like minimum of a bachelor's degree. I bet that most of those roles don't actually require you to have a bachelor's degree in order to be successful in those roles. And I think the only reason we continue to like see that over and over and over and over again is because most people who are looking for jobs don't know about this case. They don't know about this case law. So I think employees have a lot more rights than they know about.
Mm-hmm.
And that's one of the reasons that I really wanted to do. I'm not a lawyer and this is not legal advice, but if you feel like you've been discriminated against, the EEOC still exists for now. And and you can always go talk to a lawyer yourself. Don't take my word for it. Please, dear God, don't take my word for it. But I did want us to do this case because there are some really interesting things that this case brings up. And I feel like I talk about this case at companies that I've worked for. This case comes up a lot in conversation, not because the other managers know about it specifically, but they talk about the stuff that this case talks about. So they'll be like, oh, we have to be careful. We don't want to have a disparate impact. And I'll be like, yeah, that's Griggs. That's this case. And, these are the specifics about it. And, this is how the EEOC works and how it doesn't work. And here's when the DOJ gets involved and so on and so forth. So really interesting case. The last thing that I will note, Nikki touched on it a little bit, right? It was like they ruled with Griggs on this one. 17 years later, they started to walk things back. This feels to me, when I like legal decisions, this feels to me like, because the court is not static. And by the end of the 60s and the beginning of the 70s, we had 3 terms of FDR, Democrat. Well, I'll just say liberal. We had Truman, 2 terms of Truman, Democrat and liberal. Then you had 2 terms of Eisenhower, but then you had Kennedy and Johnson, also Democrats and liberals. And they were all appointing justices all through the middle of the 1900s. So the court had moved pretty left. But after Johnson, you had 1.5 terms of Nixon, 1.5 terms, or with 1.5 terms of Ford. Then you had Carter, but then you had 2 terms of Reagan, 1 term of Bush, Clinton, and then 2 more of the other Bush, right? So the court started to move right, and you see that, right? This was the tail end of that very liberal court era, the same court that brought us, Brown v. Board of Education, for instance. So it's an important case, and nobody's heard about it.
And that was even what the court said at the time, because there was one justice who I think gave an interview like the day after, and he was like, oh, this case is kind of a landmark. But when it first came out, the news was like, oh, whatever. And then it was not until time passed and legal scholars kind of sat down and started looking at it. And then they were like, oh, actually, this is a really big deal.
The other thing that I do want to throw out there is that, like, we we talk a lot. It's like, oh, here's this company, and they did this thing, and they're bad, rah, or whatever. And most of the time, that's fine because those companies generally, it's in the past, and they may or may not be around anymore. They've been acquired or whatever. Duke Power is like one of the largest power companies in the world. They're still very much around. Yeah, they're still very much around. And I do just want to note that, like, we are talking about what happened at a particular site in the 40s, 50s, 60s. We're not saying Duke Power. When we say Duke Power RAR, we don't mean like the current Duke Power. I know nothing about the current Duke Power. We're just talking about this historical thing that did happen at Duke Power at the time.
What he's saying is, Duke Power, please don't sue us.
I mean,
Duke Power, please sponsor this podcast.
Yeah.
Yeah.
We'll all take Wonderlic tests if need be.
Well, is this a surprising result?
Honestly, yeah, I'm surprised.
I'm surprised that the Supreme Court actually did the right thing.
Well, recency bias, like, we're tainted by what we know of the Supreme Court in our lifetimes in the last few decades, which is, scary.
Yeah, but after Buck v. Bell, you also know what the really far time ago Supreme Court was up to. It's really just
really
just like right in the middle of the 20th century.
Yeah, the sweet spot. Yeah.
This one was unanimous too, I think, right? It was unanimous, but there was one abstention.
Yeah, in the real case, yeah. So, yeah, all 8 were like, "Come on, Duke."
Duke is sus. Sorry, Duke was sus.
Yeah, thank you.
Yeah, it was nice to bring you guys a case where it's like, because I do remember Buck v. Bell, where you were just like, no, obviously, clearly, and then we're like, just kidding.
Oh yeah, I had trauma from that. I was
here's
like,
how
hold
terrible
on,
everything.
This seems cut and dry, but like, are you going to pull the rug out from under us again? Are you setting us up for further disappointment in the history of our nation?
The two female justices involved in this case right now feel this is very obvious. Let's see what the 9 white dudes decided in 1920.
Yeah. Still never been explicitly. People talk about how it was implicitly overturned, which whatever. And yeah, once again, I was finding reference to that case as recently as 2001. So, yeah,
wild.
Well, there we have it. A strangely, well, maybe not strangely unanimous decision. The strange part isn't the unanimity; it's that they all went for Jarrett. But
strangely satisfying result.
So you say. In any case, Thank you, everybody. Thank you so much for joining us. And once again, thank you to our Associate Justice, Serena.
Thank you for having me again.
Associate Justice, Mike.
Can't prove I was here.
And Chief Justice, Sarah.
You are so welcome.
All right, that is it. Thank you, everybody. Have a wonderful night.
Good night.
So today, the Sarah Court unanimously decided that the power company violated Title VII of the Civil Rights Act. That's it for this episode, but before we go, thanks again to my co-host and to our justices. The music in this episode was written by Studio Columna and Toby Smith and provided by Pixabay. Audio mixing and producing was done by Jarrett. Research was done by me. Thanks for listening. Please subscribe, rate, and comment so other people can find us. For complete episode information, including references, please check out our website at relitigated.com. You can also catch us on YouTube, Instagram, Facebook, Threads, and Blue Sky. Please help us spread the word. Until next time, I'm Nikki, and this has been Relitigated. Bye.